Good day, Crime Talk aficionados. It's Saturday. You know what that means. It's time for the weekly recap of all the top stories throughout the week in one convenient location. That's right. You're welcome. Thanks for watching. We'll see you next time. So I'm not really sure what to do. The other day we had people calling up at the office saying that Chris Watts was innocent. Well, now we have somebody reaching out to us saying that Chris Watts is guilty and perhaps a third party. So this man, who I won't name, reached out alleging that he was Chris Watts' cellmate at the Dodge Correctional Institution. And he's stating that a third party would have been involved in the death of the children. But yeah, Chris Watts is the one that says that he killed Shanann. He apparently reached out to the investigators, the Colorado Bureau Investigation, Tammy Lee, and these recordings were in fact taped. Now, Tammy, as you may recall, is the polygrapher. She's the expert that led the test for Chris Watts, which basically got him to break. Now, let me tell you why I think this is skeptical, okay? And why you should be skeptical of anybody saying the third party did it. First, Chris Watts pled guilty. Second, Chris Watts confessed to killing his children. And when the investigators went back up to the Dodge Correctional facility, he confessed again and told them exactly what he did. Now, what would be the motivation for somebody in prison to say that they didn't harm their children? Well, there is a hierarchy in the prison system. Sure, it's okay if you kill your ex-wife or kill your wife, but it's not okay to harm children. So I think that's the reasonable explanation as to why Chris Watts would say, yeah, I did terrible things to Shanann, but I didn't do anything to the children, because you don't want that jacket on you when you go to prison that you harm children. Let me know what you think. Let me know if we should put these tapes up. First, Barry Morphew made his first appearance in Canyon City, which is in Fremont County. For somebody that lives in Colorado the entire time, I know it's pronounced Fremont. Unlike Chaffee or Chaffee County, depending on who you talk to, even though I've lived here all my life. Anyway, the new judge, granted Barry's change of venue last week in regards to the defense request, basically saying that he would not get a fair trial up there in Chaffee or Chaffee County. So all of the upcoming hearings and the trial will be held in Canyon City. For those of you who aren't familiar with Canyon City, it's basically if you were to leave Denver, head south, drive about an hour and a half, and then you take a right. Then you drive for maybe another 30 to 45 minutes. There's Canyon City. You got the Royal Gorge. They got some railroad thing down there, and they have lots of prisons, lots and lots of prisons, both state and federal. That's where ADX is, right? Where we keep I think the Unabomber, they just moved out of there, but old El Chapo and all the other terrorists, they're all down there. Obviously, they're not going to be in the jury pool, and the correctional officers aren't going to be on the jury pool because, well, they're excluded from the potential jury panel. However, their family members are available, and everybody obviously that lives in the town and the county as well. We'll see if they can get a fair trial down here. As you may know, the defense wanted it moved out of the entire judicial district. So basically that would have meant that the Supreme Court would have had to designate a new location. But if it's a change of venues granted, the court has the discretion to keep it in the same judicial district. And in this particular case, that district has 3 counties in it from which to choose from. Now, what took place in the hearing today? Well, let's talk about that. A couple of things. Well, first, guess what? We've talked about this many, many times over the years. 404B evidence. For those who are not familiar with it, that is evidence that is being offered for some other purpose other than to show somebody has simply bad character, to show absence of mistake, motive, modus operandi, something along those lines. Well, the district attorney took nearly an hour outlining multiple alleged acts of 404B evidence, which basically amount to what they believe to be domestic violence violations as it relates against Suzanne Morphew. And guess what? The court said no, not coming in. They couldn't even meet their burden, which is only a preponderance of the evidence, right? You know how it works. Proof beyond a reasonable doubt. the standard is way up here, right? Because that's criminal case. It's so high it's off the screen. And then you got preponderance of the evidence. Simply more likely than not that the event occurred. The court said the prosecution didn't even meet that standard. Basically said it's really speculation, hearsay, and not permitted at the trial for Barry Morphew. So what does that mean? It means that Barry Morphew continues to win. One of the problems with the prosecutor's evidence is that they could not provide any specific times or dates where these alleged occurrences took place, saying only that they believe that they happened in the time since the Morphews arrived in Colorado sometime after 2010. That's right. The judge has a duty to make sure, obviously, the defendant gets a fair trial. But how do you defend against something, say, oh, over the last 12 years, something really bad happened. We're not really sure when, where, exactly what you did, but we know it was really bad. Yeah, that's not fair. So, I'm not an I told you so, but in this particular case, I told you that I thought this case was weak. It is only getting weaker by the day. Every time the prosecution has stepped into court, they have got admonished. They have been told to produce more documents that are in discovery that haven't been turned over just yet. And now their 404B evidence is not coming in. Maybe that prosecutor that left saw something on the wall before he left, and he bailed as quickly as he could. Obviously, everyone's given the presumption of innocence, and we'll see if the prosecution can pull it off, but it's certainly looking like it's getting tougher and tougher for the prosecution to win this one. Lori Vallow has a hearing scheduled today regarding competency. The hearing will be closed to the public, so no one will be able to know exactly what's going on. But Judge Boyce reviewed Lori Vallow's competency status back in September of 2021, and another competency status was due 180 days after that status hearing. So 180 days from the hearing is in September, would be right around March 22nd. Now, Lori Vallow has been at the state mental hospital since June of 2021 after mental health professionals stated that she was not mentally competent to proceed. And given the fact that there were updates and Miss Lori Vallow has not been returned to the local detention center to be held awaiting trial, is a clear indication that she is still not competent. I am a little skeptical at all that she will be restored to competency ever. I think she may never join us. And even if she does get to the state of mental competency again, it's still probably going to require another trip back to the mental hospital. There are a lot of smart people at the mental hospital there. They know when somebody is malingering or feigning mental illness, and it would appear as though she is not. Now, the one thing you have to admit, this case has gotten a little boring since Mark Means has been gone. He was a train wreck for sure, a hot mess, but at least he kept the entertainment coming. Ms. Vallow's new attorney, Mr. Archibald, is certainly keeping things much more professional. Thanks for watching. We'll see you next time.